Act.
Debate, reprise de débat, the Honourable Member for Halifax.
Thank you, Mr. Speaker. C-42. Mr. Speaker, after law school, I had the opportunity to work with a professor, Professor Wayne McKay of Dalhousie University. And Professor McKay was working on a couple of papers having to do with anti-terrorism law and privacy, where the two meet. And one paper that he produced out of this research was for a lecture at St. Thomas University in New Brunswick. And it was titled Human Rights in the Global Village, the Challenge of Privacy and National Security. Despite having completed my law degree at that time, working for Professor McKay was the first time that I'd ever really considered the issues around privacy law. And the research that I did then, the stories that I heard, the newspaper articles I read, really made a huge impact on my thinking about law generally. Bill C-42, an act to amend the Aeronautics Act, has raised all the red flags that could possibly be raised for me when it comes to the balance between making our global village function more efficiently and our right to privacy. I'd like to start by reading the opening paragraph from Professor McKay's lecture at St. Thomas because I think it actually provides us with a good framework for thinking about this bill, a bill that may touch upon our privacy rights. He begins, quote, "In the 1960s, renowned Canadian academic Marshall McLuhan coined the term global village. McLuhan's vision of the global village was that the world was a community in which distance and isolation have been dramatically reduced by electronic media. In the global village, we are crossing borders physically with travel and trade, and we're also crossing borders virtually with technology like the phone and internet. There are many benefits to living in the global village, but there are also casualties of this new world order, and one of them is privacy." End quote. Mr. Speaker, one of the casualties of this new world order is privacy, and one of the casualties of Bill C-42 is privacy. Bill C-42 is nothing more than an opportunity for data mining by foreign security services, primarily the United States, and it's an unwarranted invasion of the privacy of Canadians. I'd like to spend a little bit of time discussing what the bill will actually do and then give you some comments and thoughts that I have about this bill. So, Bill C-42 amends the Aeronautics Act to allow airlines to send personal information of passengers to foreign security services. What information will be forwarded is determined by requirements laid out in secret agreements with other countries. Details of these agreements have not been released. However, it's known that Canada has signed or is negotiating agreements with the European Union, Mexico, Brazil, Argentina, Chile, Panama, the Dominican Republic, and the United States. Details of the agreement between the European Union and the United States for the same information transfers are troubling. That agreement allows, first, that the information forwarded will be the passenger name record, which is the file a travel agent creates when you book a vacation. It can include credit card information, who you're traveling with, your hotel, or other booking information such as tours or rental car, and any serious medical condition of the passenger. 2, the information collected can be retained by the United States for up to 40 years, Mr. Speaker. 3, this information may be forwarded to the security service of a third nation without the consent or the notification of the other signatory. 4, no person may know what information is being held about them by the United States and may not correct that information if there are errors. It's hard to believe, Mr. Speaker. And 5, the United States may unilaterally amend the agreement as long as it advises the EU of the change. Apparently, there's already been one amendment whereby all documents held by the EU concerning the agreement shall not be publicly released for 10 years, so no access to information requests. So, Mr. Speaker, in essence, this bill, like I said, it's to allow data mining of Canadians' personal information by foreign security services. And there's danger that unless this bill is agreed to, the United States could close its airspace to Canadian aircraft. While this threat may result in pressure to pass the bill, it's unlikely that the United States would carry through with this threat. Mr. Speaker, the Conservatives are spinning this bill that it's necessary to fight terrorism. Well, there isn't one single example of how this data mining has caught one single terrorist. or any other criminal. And in fact, we have so many examples of how this type of information can be misused. And we've heard about it before, but I'll say this name again. Mayor Arar is a perfect example. And if you don't take my word for it, please listen to some of the testimony that was heard at committee. It was so clear and so straightforward. It's hard to imagine that the Conservatives are still supporting this bill and that the Liberals, well, we don't really know what they're doing, but we'll find out. It is fair. We don't know what they're doing. We think they're supporting it. So I'm going to read you some excerpts from the committee, Mr. Speaker, and a very, very short excerpt, but man, to the point. Jennifer Stoddart, we all know her quite well, Privacy Commissioner, Office of the Privacy Commissioner of Canada, and she said very simply, Bill C-42 raises important sovereignty issues. We are not questioning the American government's authority to implement its secure flight program. International law is clear that a state's sovereignty extends to its airspace. However, the Canadian government has a duty to protect the privacy and civil rights of its citizens. There you have it, Mr. Speaker. The Canadian government has a duty to protect the privacy and civil rights of its citizens. Et puis, Dominique Péchard.
Dominique Péchard, the president of the Rights and Freedoms League. I will read a few sentences of what she said. She said, it's illusory to think that information sent through the secure flight program will be protected, destroyed, or corrected in the case of error. On the contrary, this information will enrich the database of U.S. intelligence agencies and will be compared to information detained by all agencies mentioned above to determine whether such and such a person should be on a U.S. no-fly list or even placed on some other list. And she continues, the investigation by Judge O'Connor on the Arar case demonstrated how thoughtless sharing of information can have a prejudicial effect on someone. 4 years after Justice O'Connor's report, we're still waiting for the implementation of his recommendations, which affect the implementation of surveillance of intelligence gathering in Canada. Bill C-42 raises fundamental issues of sovereignty of Canada and the protection of rights and freedoms for Canadians. The Canadian Parliament has a right to defend these rights rather than comply with the requirements of the U.S. for supposed security considerations.
Oh, merci. I tried. Mr. Speaker, there's a great quote that I want to use. Nathalie Desrosiers from the Canadian Civil Liberties Association. And actually, Mr. Speaker, I'd appreciate if when I come to the end of my time, if you could give me the 1 or 2 minute mark, that would be greatly appreciated. So Nathalie Desrosiers from the Canadian Civil Liberties Association, this is some good stuff. She testified and she said, certainly to the extent that there is an expectation of privacy protected by the Charter, this bill would not meet a Section 1 challenge. Mr. Speaker, we probably all know, but Section 1 would say that something that violated the Charter could actually be saved because it had certain importance for the Canadian public. So it would not meet a Section 1 challenge because it has no limitations. It does not adequately protect the problems that may arise with the disclosure of information, and so on. So the first point is that there is a constitutional vulnerability that should be looked at before we go too much further. There is no requirement in Bill C-42 or in the regulations of the U.S. TSA for safeguards to protect the information. There is no safeguard that the TSA will not pass information to other government agencies, such as law enforcement or immigration. There is no safeguard that the TSA will not pass this information to third countries. And we know that this has been a particularly difficult issue for some Canadians Maribor being a case in point. There's no guarantee that the TSA will not use the information for profiling Canadians, to put them on their watch list or the no-fly list. And she goes on, Mr. Speaker, to say, I would mention to the committee that in the United States, the no-fly list is under constitutional review as we speak. It has been challenged because there are too many false positives arising. Oh, there is more from her, but I seem to have my sheets mixed up. But that's very interesting that Nathalie Desrosiers does point out that it's actually under review in the United States. We also had some interesting testimony coming from the U.S., Mr. Speaker. Actually, the Liberty Coalition, represented by Edward Hasbrook, testified at the committee. So this is a U.S.-based civil liberties organization. And Edward Hasbrook at the Liberty Coalition testified to the following. He said, unlike the case in Canada, where someone denied travel is given formal notice of that decision and has rights to appeal it, those no-fly orders in the U.S. are entirely extrajudicial. No one in the U.S. has yet obtained court review by any U.S. court of a no-fly order. It is U.S. government policy not even to admit that they have issued such an order, and that includes those denying passage on flights overflying the U.S. that were not scheduled to land. Former Secretary of Homeland Security, Michael Chertoff, is on the public record as saying that he believed that no-fly decisions should not be subject to judicial review, and the current U.S. administration has done nothing to repudiate that perspective. While the consequences for anyone are very serious, including for those U.S. citizens trapped abroad who are currently unable to return home because they are not allowed to fly and have no other way to get back to the U.S., they are perhaps most draconian for refugees and asylum seekers. You should be very clear that the enactment of Bill C-42 would grant the U.S. government de facto veto power over the ability of virtually anyone to obtain sanctuary in Canada, since in most cases it's impossible to get to Canada to make a claim for political asylum or refugee status without overflying the U.S. Imagine, Mr. Speaker. And that power of the U.S. would be exercised at the worst possible point, while a refugee is still on the soil of and subject to the persecution of the regime they are trying to flee. The Liberty Coalition went on, Mr. Speaker, to say, these data are also used for purposes of surveillance of travelers. It is not the case that the information is simply used to make a one-time decision about whether to let you fly. All of your PNRs, even if you are not deemed suspicious and are allowed to fly, will be added to the lifetime travel history and compilation of data already being kept about you as part of the automated targeting system. This includes, as Professor Salter alluded to, a wide range of information. We've been coordinating efforts by individuals in the U.S., at least by U.S. citizens who have some rights in this regard, to request these records. They include, for example, such things as your IP address, who paid for someone else's ticket, your friend's phone number you gave because you were staying at their house when you reconfirmed your reservations, or in the case of two people traveling together who made their same hotel reservations in the same PNR with their flight reservations, codes indicating whether, behind closed doors of their hotel room, they asked for one bed or two. End quote, Mr. Speaker. And that definitely smacks of all of the terrible, terrible accusations of how the long-form census, the mandatory long-form census, has violated our rights as Canadian citizens. God forbid the government know how many bathrooms you have, Mr. Speaker. But yet, here we are, by law, C-42 is saying that the government can find out whether you are sleeping in one bed or two. It's pretty unbelievable, first of all, that we would sign on to this, Mr. Speaker. It's shocking to me that we would. But what's even more unbelievable is the incredible hypocrisy of saying no to a long-form census that is just trying to figure out what the population of Canada looks like, what the population of Canada is doing, what our needs are, what our hopes are, how we're working, so that we have this information to better design programs, to better run this government, to better serve the needs of our people. That is not allowed, and yet the U.S. knows who we're sleeping with. It's mind-boggling to me, Mr. Speaker. If I still have time, I was hoping to... Oh, just mixed up with my pages here. Oh, here we are, Mr. Speaker. If there's still time, I was hoping to read a little bit about the testimony of Roch Tassé, who's the national coordinator for an international civil liberties monitoring group. So we heard from Canada, we heard from the U.S. in terms of civil liberties groups. So this is an international civil liberties monitoring group. And Mr. Tassé testified, he said, after running a risk assessment for each passenger using data mining technology, Homeland Security in turn issues a boarding pass result back to the airline. The result instructs the airline to issue a boarding pass, deny permission to travel, or issue an enhanced screening requirement. These regulations give the U.S. access to a whole subset of information on air passengers who are not entering the U.S. but merely overflying its airspace. Furthermore, this information can be shared among at least 16 U.S. agencies and with foreign governments. The program gives the government of a foreign country a de facto right to decide who gets to travel to and from Canada, since the vast majority of Canadian flights to and from Europe, the Caribbean, and South America overfly American airspace. Mayor Arar is on the U.S. no-fly list. Several other cases in which Canadians have been denied boarding by the U.S., even for domestic flights in Canada, have also been reported. Those cases include several individuals who have been deemed by Canadian courts and commissions of inquiry not to pose a risk to the national security of Canada. They include Abdullah Al-Maki, Adil Sharkwai, and others. If Bill C-42 is adopted, even the rulings of Canadian courts won't be able to be enforced. There are other concerns related to Canada's sovereignty. For example, half the cabinet members of the Bolivian government are persona non grata in the United States. So if Canada were to invite one of those ministers for a diplomatic meeting in Canada, the U.S. could bar this minister from boarding a plane to attend the meeting at the invitation of Canada. The same could apply to refugee claimants who, even if admitted by Canada, could be denied the possibility of leaving their country by the U.S. Other impacts on refugees and immigrants include the possibility of mistreatment abroad by third countries with whom the U.S. might share travel information. By adopting Bill C-42, Canada could become an accomplice in the U.S. rendition program, which is already responsible for the torture of Canadians in Syria and Egypt, among others. At the very least, it would support Canadian complicity in a foreign government's program that violates due process and the principles of natural justice. Disclosure of personal information to the Department of Homeland Security on passengers traveling to certain destinations, particularly Cuba, could lead to unpleasant consequences. For example, this information could be used to identify Canadian companies that do business with Cuba, or to penalize travelers who have visited Cuba by subsequently refusing them entry into the U.S. How will Canada ensure that the U.S. will not use the Secure Flight Program to apply its Helms-Burton Act, which imposes penalties on foreign companies doing business with Cuba? End quote. So again, that was Roch Tassé, National Coordinator of the International Civil Liberties Monitoring Group. And these are pretty ominous predictions, Mr. Speaker. And I'll wrap up by saying that in 2006, internationally acclaimed Canadian author Rohinton Mistry canceled his book tour after being repeatedly harassed while flying to and from the United States. Mr. Mistry is not a terrorist, he's not a criminal, he is a national treasure, but he's a very unfortunate victim of flying while Arab, or, as it has become, Arab-looking, or with an Arab-sounding name, or having any skin tone other than the ruddy white of the British Isles, and having a name that would be uncommon on the Leave It to Beaver show. Mr. Speaker, Rohinton Mistry's critically acclaimed novel, A Fine Balance, sums it up. We need a fine balance when we're weighing the global village's needs against our privacy rights, and this bill gets it wrong. Thank you, Mr. Speaker.
Questions and comments, questions and commentary. The Honourable Parliamentary Secretary to the Minister of Transport.
Thank you, Mr. Speaker. And I did hear one thing from that NDP member that was correct, and that is, Mr. Speaker, that she labeled this as an issue of Canadian sovereignty, and she's right, because it is an issue of Canadian sovereignty just like the United States expects us to respect their right to their sovereignty and their right to their airspace, we expect them to respect our right to our sovereignty and our airspace. So how, Mr. Speaker, can we expect them to do so if the NDP won't even let us pass this law in order to respect their right to sovereignty and expect them to do the same? Now, she asked for for examples, Mr. Speaker, as well, as to where this was used in the past, where the U.S. has actually filtered a list and utilized it, passed it on to enforcement agencies 3 times in the hundreds of millions of passengers a year through the U.S. 3 times they have done that, Mr. Speaker, and we did receive information from the ambassador on that. So 3 times out of hundreds of millions. The fear-mongering this member is trying to do and the NDP are trying to do through their filibuster is just simply ridiculous, Mr. Speaker. But I will say this to the NDP member. Now, she actually has an advantage, Mr. Speaker, because the hard work of the Minister of Public Safety, he got an exemption for us. He got an exemption for Canada, the only country to receive an exemption, Mr. Speaker, for those flights that fly from Vancouver, for instance, over to Ottawa. They actually pass through U.S. airspace. And this member, for instance, takes advantage of that. So I would think she would stand up and say, thank you, Minister, thank you, Conservative government, because you got an exemption for us, and your hard work is paying off for Canadians, keeping us safe, keeping our economy strong, Mr. Speaker. That's what she should be standing up and doing right now.
The honourable member for Halifax.
I'm not sure I heard 100% correctly, but I think the member said that the minister has worked hard to get an exemption for us in flying to Ottawa. Yeah. Okay. Okay. Yeah. Just checking. And Mr. Speaker, that's the craziest thing I've ever heard. I'm a member of Parliament here, and we have a lot of rights and privileges that come with this role. But we shouldn't have preferential treatment for flying to Ottawa when we're coming here to talk about what's going on in Canada. This is nuts. What about when we're trying to get to Ottawa? What about this guy here? There's a British man who is stranded in Toronto, and he can't get home to England. Why? Because he's on a no-fly list and he can't fly over American airspace. He's saying, how can you tell me I'm not allowed to go to my own country? He has no rights here because he's not Canadian. He's been denied access to U.S. airspace and he just wants to go home. Look at the bizarre results of blindly going ahead with this ideological bill to say, we got to do whatever the United States does because we're like that little dog on the Bugs Bunny show, always with the big dog saying, we're there with you, we'll do whatever you want. It's time for us to actually stand up to the United States and do what's right for Canadians.
Questions and comments. The honourable member for Burnaby, New